Welcome to the fifth module of this course, which is about the data protection board. In the third module, we have discussed the duties and obligations of the data principal. In the fourth module, we discussed the duties and obligations of the data fiduciary. In this module, we will cover the other key stakeholder, which is the government, which will play an active role in this legislation by way of the data protection board. A board called the Data Protection Board of India shall be established by the central government, which will have a dual objective and purpose. One objective is ensuring compliance with this legislation, that the data principal and data fiduciaries and the data processors follow the procedures prescribed under this legislation. That is one objective. The second objective, it will also act as a go-to point for the data principal. So, data principal can go with his complaints to this board, which will conduct an inquiry, and it can pronounce decision and impose penalties wherever applicable on the data fiduciary primarily. With some exceptions, it can also impose penalty on the data principal. The board will be headed by a chief executive along with the officers and employees. The legislation does not give the details of how will the board monitor and ensure the compliance with the act, but it does give some details about what the board will do when it receives a complaint from the data principal and a process has been prescribed, and the board shall follow the following process when it is inquiring into the affairs of the companies and corporates who are acting as data fiduciaries but have not met the requirements of the data principal. Once the complaint is received, the board will decide whether there is any sufficient grounds to proceed with the inquiry. So, one of the obligation of the data principal is also that it should not take any frivolous matter to the board. So, first it sits to see whether the matter can be admitted and whether there is any sufficient grounds to proceed with the inquiry. Once it agrees that there is sufficient ground, it can inquire into affairs of any person, any company to ascertain whether they are in compliance with the act or there is any violation has been caused, and they have the power to summon any person, any data, any book, any register, any of the records for the purpose of inquiry. They shall also have access to the premises, goods and equipments, and they can visit the premises for investigation on the matter. Just like any other court or the forum, they will provide a reasonable opportunity to the other person to submit his views and contentions before any order is passed by the board. So, the board has been granted the power of a civil court and under the CRPC. So, it shall exercise that power in while issuing the orders and ensuring that the companies are compliant with the legislation. So, the board has a significant sweeping powers in terms of issuing summons, causing for documents, doing an inquiry, visiting the premises and all that. Therefore, it is critical for the data fiduciary to ensure that there is no violation of the provisions of this legislation. There are certain additional features in terms of the review of orders of the boards and appeal. The board on its own or based on a representative made can review its own order through a larger group and pass order accordingly, either holding by its earlier stand or making amendments as may be necessary. So, it has the power to review the order that it has passed. If any appeal has to be made against the order of the board, that appeal shall directly lie with the High Court, and that should be made within a period of 60 days. And no civil court shall entertain any of the suit or any action in respect of matters under this provision. So, it is the exclusive jurisdiction of the board to entertain the complaints of the data principal of the data fiduciary under this legislation, and the civil court shall not be entertaining it, and any appeal to be made against the order of this board shall lie with the High Court. The board may also accept voluntary undertaking from a person, people or a data fiduciaries who do not want to be a part of a protracted litigation may undertake corrective measures to ensure that the requirements of data fiduciary are met, or any non-compliance that has been done will get corrected. So, they may give a voluntary undertaking to the board stating that they will comply with it, and in such a voluntary declaration case, the board shall not proceed with any further proceedings. But however, it is critical to ensure that the voluntary undertakings are met and not just merely given to escape the proceedings. So therefore, in the event of any failure to comply with the voluntary undertaking, the board will initiate the financial penalties. So in short, the government intervention comes through the Data Protection Board of India with dual objective of ensuring compliance with the legislation and also to act as a grievance forum for the data principle. It has a set of defined procedures on how it will go about once the complaint is received from the data principle. The board has the powers of a civil code and can summon any person, any document or visit any premises for the purpose of inquiry. The board will have the powers to review its own order through a larger forum. Any appeal against the board order will be with the High Court, and the civil courts are not going to entertain any matter in relation to this legislation. And the board can take voluntary declaration from persons who state that they will comply with the legislation and not carry any proceedings against them. And in case of the voluntary declaration commitments are not met, the board has the power to impose financial penalties on the defaulter. We come to the end of this 5th module on the Data Protection Board of the India. In the next module, we will discuss the fines and penalties that can be imposed by the Data Protection Board.